Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to Finding Me on the ITV networks. Today with a very special and distinguished guest. Professor Tladi is a professor of international law at the University of Pretoria. He is also a member of the UN Commission of International Law and has been appointed to this particular membership since 2012. Professor Tladi has written a book, It's Blood in the Sands of Justice, and has written numerous articles covering different aspects of international law. But my discussion with him today is specifically about the Sudanese President Omar al-Bashir, his visit to South Africa, the warrant of arrest, and the South African government's response. So with that, I'd like to say welcome and thank you very much for making this time in your very, very busy schedule.
Thank you very much for having me.
Professor, let's just get straight into this matter now. Okay, so we have this issue where South Africa is presented with a major challenge. You have a head of state that's coming to visit you. There is an international criminal court warrant of arrest out for him. But also at the same time, there is the immunity from the AU. South Africa had to respond in a particular way, and this response has been interpreted all over the show by different parties, but you have a different take on it. The first comment I want you to raise, and which is I heard in your debate recently, which you presented at the University of Pretoria, was that this is not a simple matter. So can you start by explaining why you say that this is not a simple matter, it's not black and white?
Yeah. I think if you listen to a lot of the discussions that have been going on since this whole affair started, you have two camps. And one camp appears to be arguing on the basis of law, while another camp appears to be arguing on the basis of politics. The camp that is apparently arguing on the basis of law makes it seem as if everything is simple and clear-cut, that there was a duty to arrest and surrender, there are no exceptions, and that the failure to do so amounts to a violation of the rules of international law. So that's the narrative. And one can understand where this narrative is coming from. The crimes that have been committed are, of course, horrendous crimes. And, of course, there is a desire on the part of many to see justice done. But we have a system. We have created a system of rules, and it's not a perfect system, and we have to accept that system with all of its flaws. One of the flaws of this system, of course, is that it recognizes rules relating to immunity. So, the argument that has been advanced is that in terms of the Rome Statute, there is no immunity for heads of state. And that is true, but only with respect to proceedings before the International Criminal Court itself, right? And so Article 27 says that the fact that someone is a head of state shall not be a bar to the court's exercise of jurisdiction. So it really is applicable as between the individual and the ICC.
Okay, so let me just stop you there, because we're dealing with a lay audience who are not very familiar with the law. Basically what you're saying is that any head of state, so president, a prime minister, etc., will not be granted immunity, but that is only applicable when he is brought before or she is brought before the ICC, the International Criminal Court. Precisely. So it doesn't happen, it's not applicable to any other situation.
Precisely. So it doesn't affect rules of international law that grant officials, like heads of state, immunity from the exercise of jurisdiction of foreign states. So, for example, there is a rule of international law that a state like South Africa must respect the immunity of officials of Sudan, including its heads of state. So that's a relationship between the two states. Article 27 doesn't deal with this relationship. So to argue that because there's Article 27, then there is immunity is wrong. So that's the first argument that has been advanced. But there is a second argument that has been advanced. The second argument that has been advanced is that in this particular case, so in the case of Sudan in particular, there is no immunity because the situation was referred to the ICC by the Security Council, and in terms of some very complicated rules, obligations that flow from Security Council resolutions under Chapter 7 trump other obligations. And so the argument then would be that because this was transmitted to the ICC via Security Council resolution, the rules of immunity are trumped, if you like, by the Security Council.
So they would have to basically they have to bear value in the South African situation as well.
Yes, so which means that that essentially he doesn't have immunity, or anyone who's indicted via that process doesn't have immunity, even before domestic courts of other states. The problem with this argument is that the resolution doesn't say that. I mean, if the resolution did say that, then the argument would be valid. So if the resolution had said explicitly that there is no immunity, or for the purposes of this referral, immunity is not recognized, then the argument would be absolutely correct. It is also possible that the council could have done it in another way. The council could also have decided that it places an obligation on all states to cooperate with the ICC. So then there's an obligation on states, including South Africa, to cooperate with the ICC, and that obligation flows not from the Rome Statute only, but it also flows from the Security Council resolution. And to the extent that it flows from the Security Council resolution, then it would trump other obligations. The problem now is that the obligation on South Africa to cooperate in the arrest and surrender is a normal treaty rule that comes from the Rome Statute. So it doesn't trump necessarily other rules. And of course, there are other rules, and I've already mentioned the rules of customary international law relating to immunities, but there are other rules as well. In this particular instance, we also have the host country agreement. So we all know that the attendance of Mr. Bashir to the summit, or rather his presence in South Africa, was to attend the African Union summit. For any meeting, there is always a host country agreement between the organization that is responsible for the meeting and the country that is hosting. And a standard clause in all of the agreement is an immunity provision, right?
Okay, so it's standard.
So it's a standard. It's not. It was not included specifically for
this.
Right. It's always there. It's a standard agreement. For example, the United States hosts the United Nations. There is a host agreement. That host agreement has a similar provision which grants immunities to diplomats who are accredited, but also to officials who are attending meetings of the United Nations for their states, right? So this is a standard standard provision. So this is also a rule of international law because it comes from a treaty, just like the Rome Statute. Right?
So there's no hierarchy?
There is no hierarchy between these two treaties, right? So they are both sources of international law. And so the point I was making then about the fact that this isn't a simple thing was simply to say that there is in fact a conflict of obligations. There is, I think, an obligation to arrest and surrender under the Rome Statute, but the Rome Statute is not international law. It's part of international law, but it's not international. It doesn't subsume all of the other rules of international law. On the other hand, there are rules of international law that says that a head of state is inviolable, may not be arrested. Courts of foreign states may not exercise jurisdiction over them.
So are there really rules that say that? Because are there really rules that say that? Because if they are, I mean, what's the purpose of justice then? Because ultimately, in most cases, the buck stops at the top. And so if the top is inviolable, then how do you get justice?
I mean, there's a variety of ways that you can get justice. But the importance of immunity was emphasized by the International Court of Justice recently, well, not recently, I guess in 2002, when it stated that this is a fundamental rule of international law that permits states to be able to relate with one another. So it obviously has its negative consequences, but you have to understand that it's an important rule. I mean, how would we feel if our president were attending a meeting and someone decided that they were going to arrest him, right? And it doesn't matter whether or not they feel it's justified or not, right? The fact is that there are these traditions between states, and these traditions have crystallized to become law, that they have to be respected. Now you ask me a question then, what does this mean for justice? In the very same case that I referred you to, the International Court of Justice case in the arrest warrant, the court mentioned a couple of ways in which a person with immunity could still be brought to justice, right? So one way, for example, would be that once he's no longer the head of state, then he doesn't have that absolute immunity, right? So that's one way in which a person who commits these kind of crimes could be brought to justice. Another way could be that the Security Council, when it adopted the resolution referring a situation, could provide, for example, that there is a duty on all states to cooperate, or could provide that for the purposes of this referral there is no immunity.
So there's a loophole in the way the text is formulated.
Right, there's a loophole. But let's remember that there are many loopholes. It's not just with respect to this situation. I mean, there are loopholes. For example, we say, why is the ICC not engaged elsewhere where there are also crimes? And the response is because it doesn't have jurisdiction. That's a loophole. I mean, if you're willing to accept that loophole, why can't you accept this loophole, right? So this is a loop. This is a system that we have created, and I think we have to respect the system, or else we risk damaging the system.
Yeah, so we have to go to a break, but very quickly, do you feel that, for those who want justice, a very quick thought, do you think that the system, in spite of its loopholes, can deliver justice?
Yes, I do. I think that institutions and systems take time to build. And I think that the system that we have, with all of its flaws, is fundamentally a good system if we allow it to grow. But we have to allow it to grow. We have to give it time. We have to give time for other states to become party. Then I think the system that we have eventually will be a system that can deliver justice. But if we try to do too much too soon, we might simply break the back of what is inherently an excellent system.
Okay, but we have to go to a break now, so we'll take the conversation when we come back. And we'll see you after the break. And welcome to the second segment of Finding Me today in the ITV networks with my distinguished guest, Professor Tladi, International Law Professor at the University of Pretoria. Now, before we went on to the break, Professor, kind of admitted that the system is good. The system will produce justice, but we have to we'll take gradual steps. But Professor, my question to you now, based on what you said, I mean, that was an optimistic point on which you ended, but also very pragmatic. The question is that the system does, however, need to be adjusted. For example, everybody should be party to the Rome Statute. Otherwise, like you say, there's jurisdiction and there's no jurisdiction, and so some will get away, but others will continuously get charged. So people will say, but where's the justice in this? For example, the argument right now, it's a witch hunt of African leaders. That's what the ICC turns around to be. So how do you then adjust, or how do you envision that we will get this level playing field when on its own, the United Nations Security Council, the way in which it has been formulated, the right of veto, etc., presupposes a hierarchy, a privilege to certain states, and there is no indication of a willingness to change that dynamics or that power struggle at the moment.
Yeah. So there's two parts to the answer that I can give. The first part is that the idea of getting all states to ratify is in fact central to the objective of the Rome Statute. I mean, if all states were party to the Rome Statute, then a lot of the discussions that we're having simply don't occur. In fact, the provision, which I don't think I mentioned here, but an important provision relating to immunities really stops being relevant at all, and that is an exception to the duty to cooperate, which is found in the Rome Statute, because it's specifically for non-states parties. But that's not related to the system, at least not the International Criminal Justice System or the ICC system. That's related more to the international law system as a whole. I mean, the international law system as a whole is based on the idea of consent. So you cannot be bound as a general rule, and there are some exceptions, but you cannot be bound to rules that you have not specifically consented, and certainly not to institutional rules. And so while it's possible to say there are certain rules that are so fundamental, certain substantive rules that are so fundamental, that are binding on everyone, when you come to institutions like the ICC, a state has to consent, and that's the fundamental premise of the international system as a whole, and not so much of the ICC.
So is that why you said that South Africa was not obliged to arrest him, but that basically it had to decide whether it was going to cooperate in the warrant?
Well, my view on that was a little bit more nuanced. So my view on that was that, well, South Africa is obliged as a matter of international law to arrest and surrender him. That's one thing. Is obliged as a matter of the Rome Statute to arrest and surrender him. They are obliged, and of course the Rome Statute is also a rule of international law. But, and this is the nuance, they're also obliged by other rules not to arrest them. And so essentially there's a conflict of obligations there, right? And what is needed is a way to resolve this conflict, but there is a conflict of obligation, and my concern is the unwillingness of persons to see this conflict of obligations. The second part of your question, which I think is really a fundamental question, is the inherent inequality of the system, right? Because you've got the Security Council and so on, which has the power to refer. Again, the issue is not with the ICC. Again, this is a fundamental flaw, if you like, of the UN system, right? And so if we're going to be critical about that aspect, then I guess the criticism should be directed more at the United Nations rather than the Security Council. Now, of course, you can turn around and say, but the ICC has built into itself, through negotiations, this inherently unequal system where the Council can refer a situation to the ICC. But the reality is that essentially the Council doesn't need the ICC. I mean, the Council could have done what they want to do in the same way that the Council established the tribunal for the former Yugoslavia or Rwanda. So even without the ICC, the Council could do right. So I think, again, in terms of a systemic thing, the issue here is not related to the ICC, but rather related to
the broader UN.
Right.
Okay, so now you said there's been a conflict of interest, a conflict of obligations on South Africa's part in the manner in which to deal with this. On the one hand, yes, they have to arrest. On the other hand, no, they're not obliged to arrest. South Africa, as a government, of course, being fully aware of the treaties that it has signed, both domestically and internationally, don't you think that the government should have been prepared for this fiasco, considering that they knew that there was a warrant of arrest that was being issued for Bashir? Secondly, that it was being brought to the domestic courts. And so, I mean, if you're saying that there was a way for them to argue this, shouldn't they have been more prepared rather than presented the way it has evolved or the way it has erupted? It's almost as if it was a fiasco, as if, the government just took the law into their own hands, ignored the court order, let Bashir go, and there was no substance to the action of the government. Now, if there is law, loopholes within which to work, shouldn't the state have been more prepared for this so that we don't look so bad?
So that's a very good question and a very difficult question. I'll again look at the question from two parts and say one part I will not be in a position to answer, and that is the so-called ignoring of the court order, because as you know, of course, that's a matter that's still under investigation, right? The court in its judgment required the respondent to provide affidavits as to how the man left in order to determine whether in fact they just let him go or he slipped out or whatever the case may be. And so that's an issue but the broader question though is, should the government not have been more prepared and not have dealt with this thing much earlier? The problem, of course, is that the government didn't institute an action, right? It was not the government that instituted an action. It came from the South African Litigation Center, and the papers were filed on the weekend after his arrival, right? So, for example, the papers were received by most of the respondents an hour before the matter was set down for hearing on the Sunday. That's not a lot of time to prepare. Now, remember this. The government can prepare legal arguments for itself and say, well, this is the position as far as we interpret the law. But the government cannot go to court on its own and say, let's address it. You have to wait for the implication. And of course, for the South African Litigation Center, it was important that the litigation is only started after the arrival, which means that it becomes really difficult then to have a conclusion, an authoritative interpretation before his arrival. And so that is in fact what results in the fiasco. I guess the best case scenario would have been if, I mean, we all knew as of January, I guess, that the summit was going to be held here. That's when I found out in the newspapers. I guess the best case scenario would have been had the South African Litigation Center already at that stage, as soon as they were aware that this issue is coming up, filed papers to say, we are aware that there's a possibility that he may come. We want this matter resolved. That would have done a couple of things. I mean, I think, at least for me, the most important thing is it would have enabled both sides to prepare properly rather than have an urgent application, which is what we had, with both counsels not being properly prepared and therefore the court not having the benefit of a properly argued case. If the case had been submitted earlier, there would have been time to engage in proper preparations and proper arguments, and I think eventually a proper judgment that takes into account all the facts, all the laws, and so on.
So it would have been to the benefit of the law of this country and perhaps brought out the best of what we see in terms of how the law is interpreted, I suppose. Hey, but then one could then argue, then when you said there's two sides, one is the law side and the other side is the politics side. So then was this, this petition which is brought before the court, perhaps then was it politically motivated from the law center?
So I wouldn't want to say that. I mean, no, I wouldn't want to say that. I understand that their role is the promotion of human rights. So I don't know that it's politically motivated, particularly because as I understand, according to the papers that were filed before the court, there was a claim from the South African Litigation Center that they had requested the government earlier to take steps. But I still think in terms of judicial process, that's not sufficient. Right? What would have been sufficient would have been to engage in a court process to ensure that we have a properly argued case with a proper decision, rather than what we saw with one counsel, for example, relying on a particular text, the judge asking them which specific paragraph, and the counsel doesn't even know. Right? Okay. So that's the kind of thing that we would have been able to avoid if the application had been done on time. Okay, so we're almost at the end, and I just want you to verify for me. You speak about customary international law. Is that more important than the Rome Statute for South Africa, or how does South Africa balance the different treaties or the different interpretations of law? And most importantly, does domestic law trump international law, for example, in this particular case for South Africa? Okay, let me start with the first question, relationship between customary international law and treaty law, and which is the most important one. There is no a priori hierarchy between the sources of law. The difference is that customary international law is general law which applies to all states, whereas treaty law is specialized, which applies only to states parties. I think that's the difficulty. There is, in some quarters at least, a willingness or a view that treaty law is more important. But I think that's more of a practical thing rather than a legal doctrinal thing, because with treaty you can see the rules, whereas with customary international law you have to find them, and often this is an art rather than a science, so that I might say something is customary international law, you might not agree, whereas with treaty you can see the rule, it's explicit. The relationship between domestic law and international law is slightly more complicated. Your question is, does international law trump domestic law or vice versa? Well, it depends. It depends on which system you're operating in. If I'm arguing before an international court, then of course domestic law is irrelevant, right? So in that respect then, yes, international law trumps domestic law. But if you are arguing before a domestic court, then the reverse is true. South African courts apply South African law, not international law. There is, of course, a role for international law through various means, including through interpretation. But in terms of what is applied, the courts in South Africa apply domestic law.
So in 10 seconds, very quickly, do you believe South Africa could have got away with allowing Bashir to leave had the arguments been more properly prepared in terms of public opinion?
So I think as a matter of law, if there had been properly prepared arguments, I think courts would have been very sympathetic to the views of South Africa, and we may in fact have had an outcome that says there isn't a duty to arrest. I also think that if this message had been properly sent out, then the public also would have been a lot more sympathetic rather than seeing the authorities as simply flouting rules of international law, but understanding that in fact there was a conflict, not of law versus politics, but of law versus law.
Yes, okay, but thank you very much for that, and I think perhaps people will have a much better understanding after this particular discussion. So again, once again, I'd like to say thank you for sharing your time and for sharing your expertise with us, and perhaps we'll call you back again because there are many other issues that are going to be coming up soon that we need to talk about. Until we meet again, fi amanillah, wassalamu alaikum wa rahmatullah.